Mouse.
Please do not be alarmed by anything you see or hear around you. You are bound to feel some initial ill effects as you've been rescued from certain death at an improbability level of 2 to the power of 267,709 to 1 against, possibly much higher. We are now cruising at a level of 2 to the power of 25,000 to 1 against and falling, and we will be restoring normality as soon as we are sure what is normal anyway. Thank you.
WDRM production. WDRM production staff may be considered complete works of fiction. Any similarity to reality is only due to the conventional grasp of perspective vortex. Please adjust your perspective, vortex, translator devices for enjoyable listening pleasure. WDRM can take no responsibility for improperly adjusted perspective vortex translations and currently operating at the frequency of somatic 900 MHz.
Hey y'all, Fusing the Agenda here. If you're an independent journalist struggling to get your story out, contact one of our mediators in our chat room for review. Get your story featured on the Hawk Ethernet Radio, part of the Wicked Development Radio Network. Flash submission guidelines. Video or portion must not be longer than 3 minutes. Only be played with a startup point of 3 minutes. All material submitted to WDRN is the sole responsibility of the submitter. All content is fair use practice. With your help, WDRN will rise to the top of all available news networks. This has been Defusing the Agenda.
Mouse.
All right, look at that. Oh, you got your volume up too high. There we go. All right. Let's see. I'm not going to be making too much comments of this, other than the fact that the prosecutor, prior to having a conference with me, get this, failed to review the case. I've had 3 different prosecutors entrenched to continue these charges, and none of the 3 actually reviewed the case. Now, the highlight, that's one of the highlights. The other highlight is the fact that the judge dismissed the motion to dismiss, he denied the motion to dismiss without a single freaking word by the prosecutor. The prosecutor did nothing but put his laptop up and then buried his face in it for the entire hearing. Didn't say a fucking word. He knew better. So, now that I've gotten, so much established. Don't forget, we're in a court of record where the verbal testimony is also taken, just like in the TROs. So, I established quite a bit. Then I looked at it, and I realized that what I have not broadcast, what I have not shared with you, is the event that they would actually try to continue. I haven't shared that with you. And prior to getting a public defender, I needed to have X amount in the record. A concession, well, it must be much more complicated than a high school diploma can handle, regardless of whatever additional training I may have had. And due to high volume of the court, the prosecutor couldn't even review it, and he was given time to review it. They were given time to review it, but now we're back to square one. There is no plea deal. There's no plea yet. There's no entry of a plea, nothing. Nobody could move the court. The court was unmoved. The prosecutor wasn't going to move it. So the judge did. I think the judge actually likes me now. He knows I'm not there in order to sit there and just throw fluff at his face. He recognized the seriousness of what I have submitted to him. And the other thing that you guys wanted to sit there and make fun of was the conversation I had with GPT concerning a sidebar. Well, that was a distraction for you to keep you sit there and your lips flapping over nothing. Okay, oh, he's going to get arrested if he tries to do a sidebar. Oh my God, the ridiculous things these people come up with. So, instead, I'm going to go ahead and let the reality play out. Anybody that's actually objective might be able to figure this out. If you're not, well, then you're not. This here is courtesy by an illegal act of Cheeky Monkey having recorded the court hearing against standing rule of not to here in Larimer County. If he's a citizen or, person of Colorado, he might be wanting to consider that. All right, so here's the hearing itself.
Morning, Your Honor.
Good morning.
I want to apologize first for my emotional response. I am not trained. In my last hearing, I had an emotional response I'd like to apologize for.
Well, thank you.
Basically, I have a motion for dismissal here. It's based basically on the fact that I still don't have a description. Now, according to the docket of this case, they did indeed file a summons and a complaint. I have not still got that complaint. This is the third time I've come to court. But in addition to that, when I started looking into the evidence that was parallel to this case, I also discovered the original police report that was filed by Robert Thayer into a civil case. So I was able to obtain this. In this report, there is no intent. The only intent it describes is exactly where the report starts, and that's at the courthouse here. And my intent was to serve him. He had evaded process prior all the way up to October 20th. What is odd about it is October 20th wasn't necessarily my court date. It was his own court date that he had missed while he waited for me to come out to the parking lot.
So Mr. Fredericks, let me stop you for just a second and let me tell you why, okay? So a couple things. One, I'm going to print out a copy of the summons and complaint. So it may not be the...
Well, it's not just that, Your Honor.
No, let me finish, please.
Yes, Your Honor.
Yeah. So the summons and complaint is maybe not what you're expecting, but it complies with the statute regarding giving you notice about why they've charged you.
Your Honor, the only thing I need, if I was responsible and I was supposed to press this button, that I did not press that button, or in the inverse, if I was responsible and I was told not to touch that button and I press that button. These are the elements that I need in order to be able to plead to. And I think it's ridiculous the third time. Not only that, as I said, Your Honor, as I dig into what is available to the prosecutor, okay, and this also needs to be mentioned. I only just found that he has not reviewed this case yet. This is my third prosecutor that has not reviewed the case. And it places them in a very tough position because then they have to take hardball during a conference, which I had shortly ago, but I learned that he hadn't had a chance in order to review the case before the conference, setting the tone of the conference completely confrontational. I do believe that this case suffers from SMEF, sudden massive existence failure. And it would be easy in order to identify if anyone with a legal degree or knowing the latches of law would actually review this. My comment before was the fact that this is not a college level. This is a high school level. And when I look at the police report and any of these documents, it is a two-part charge. Now, a summons is fine in order to get a summons, but it is not designed in order for a multi-part charge. It is designed of who, what, where, how, not referencing why, because why would be the intent. And a normal traffic ticket, even though it may be normal for the court, it does deprive somebody in a harassment condition to know exactly what action they had taken in order to be charged. So this is kind of where it is, and this is the reason why I'm frustrated. And having knowledge of this case, there's other things. They have been presented with over 150 hours of video for the last 3 years, in which I was calling Robert to court to stop him from harassing me. And then the moment that I go out and try to serve him, I have a third party with me. I have the Fort Collins Police Department there in order to serve him, because he was managed to evade process before, and it was on the process. Hey, there's plenty of activity inside, but nobody's answering. Knowing.
So, Mr. Frederickson, a couple things that are important here.
Yes, sir.
First of all, this has been given to you before.
Yes, sir. That's a summons.
It is a
It doesn't have why. It has all the elements except why.
I understand.
Okay.
But why is not required. Okay. I think you are confused about that issue, but I mean, what I can do that may be helpful is I can give you the jury instruction for this offense, and that does spell out the elements.
Okay.
So
I don't know why we would proceed past today, however. It's been,
let me tell you why. Okay. The reason why we will proceed after today is I think you are focused on this issue of probable cause for the offense. A misdemeanor, you're not entitled to a probable cause finding. So you don't get a preliminary hearing like you do in a felony. And so basically it kind of just.
Your Honor, again, I think there's something just basically, and excuse the term because there's so many puns to it, is order. The order of which things happen. This gentleman didn't have a chance in order to review this case before he had a conference with me. I don't know him from Jack, and we had a negative response. And yet at the same time, if he had the chance in order to review these documents prior to that conference, he would be in agreement with me. I strongly feel that. There is no answer. There is no answer to this motion to dismiss. If the prosecutor would like to just simply remain silent and allow it to happen, I will agree with that.
Well, I'm going to deny your motion to dismiss because it's based.
Your Honor,
it's based on.
At this point, I would like to request to go ahead and ask for, because this has now exceeded any high school or any understanding I could have. So I would like to ask for leave in order to apply for a public defender, because this is ridiculous.
Okay.
I don't know how else to handle it. The order in which things happen makes it a legal impossibility for me in order to work with people.
That's not a problem, Mr. Frederickson. It's okay. Yeah. And so we've got an application right there. Do you know where their office is at?
Is this the?
Yes, sir. Yes. Okay. So the first page tells you a little bit about how to contact them. Do you know where their office is at?
I do. It's downtown in the Walkway Square. I perform there sometimes, Your Honor.
Okay. Yeah. Number 1 Old Town Square. So you're exactly right. You just go to the second floor over there. I would encourage you to go just straight to their office from here.
May I relinquish the documents I have here and assure the court that I'm going to be doing this right now?
No, because we haven't confirmed that she will be representing you. So until.
Oh, I see.
You see what I'm saying? Just hold on to those, and then if they determine that you qualify and that they'll be representing you, absolutely you can provide those to them. Okay?
May I ask the prosecutor a simple question? Because I understand that he hasn't had a chance in order to look at it, and there are so many other things wrapped up in it. This is complicating other issues, and I would like to end this leg of it only because I would have the cooperation, not the objection of the prosecutor's office. But, sir, do I have your assurance that you will not have another associate work on this? That
I have no control over
somebody
that,
that
sir.
actually is rehearsed in what this case is actually about?
So, Mr. Fredericks?
Yes,
Mr.
sir.
Fredericks,
I mean, that's one of the problems is I've had 3 prosecutors and it should have been ended with the first one.
I understand how that can be frustrating, but let's follow the path that you've suggested, which is let's see if you qualify for a public defender. Let's see if we can get an attorney to represent you. And then they can deal with that negotiation with the DA, regardless of who it is, with the understanding of the law, and
Your Honor,
they can convey.
I'm not trying to blow my own horn here, okay? But for the last 4 years, I have been doing homeschool for law, and it flummoxes me. I don't have the style. I don't have the experience in order to make a verbal presentation. I understand that, and I probably am a little too crude for it. However, the paperwork that I have performed and the work that I have done, I think was very substantial.
Well,
And
I'm not saying that there was anything inadequate in the quality of the work.
what I'm saying is,
what
what
I
I'm saying
see
is I
is
know the elements of what's happening here. I wish that someone would catch up and get ahead of me,
Well,
because it would prevent
why don't you?
collateral issues, Your Honor. I mean, just really, I don't need them on my plate.
Okay, well, let's get your application into the public defender's office.
Yes, Your Honor.
See if you
Do I
qualify.
turn that in here, or do I turn that in downstairs at the clerk's office?
No, you turn it in at their office. That's why
Okay,
I asked
not a
you if
problem.
you knew where their office. Okay, can you go over there today?
I will go over there immediately. I can't come into town very often, Your Honor. I don't.
That would be
And
great.
part of the reason's right here. I stay at home. I don't leave. When I walk out the door, I have to check the horizon. And being ex-military, it's very annoying to do that at 63 years old.
So, knowing that, how about if I bring your case back on February 18th at 9?
February, oh, this month still.
Yeah.
That works for me. I appreciate
I mean,
that.
I can do it as soon as next Wednesday, but I don't want to.
Well, no, I mean, if they're stacked up, Your Honor, he didn't have a chance to look at it. It's not going to help if they don't have a chance, you know? I agree.
Right.
You know, so
Yeah, but that's what I'm thinking is that'll give them a little time to look at your application. If you need to provide them with any additional paperwork or, so what they will look at, of course, to determine whether or not you qualify is your income.
well, as I said, I don't leave the house. I have a little bit of work that I do to offset my rent. On a parallel but completely different subject, Your Honor, did you receive my letter for supporting judicial directive?
I did.
I,
Yeah, I mean.
you can understand, I'm a
related to the
repairman.
VA's.
I don't come in and say, hey, look, it's broke. You know, I don't do that. So quite honestly, after this hearing, I don't know if he looked at it, if she looked at it, I think they would actually give you whatever cause it would take in order to get a directive with internal. If such a panel existed, it would streamline the position and prevent what happened today, whereas he's, you know, refreshing a case he has never seen yet, et cetera, so forth. It would create a triage
Well,
for the court.
I understand.
So I hope that was somewhat helpful.
Okay, well, let's
Uh,
get you
is
over
that
to the
all you
public
need?
defender's office. Let's have you return on February 18th at 9.
February 18th.
And then, of course, I always have you sign your notice.
9 o'clock?
Yes, sir.
And I promise, oh, look, you won't let me steal your pen this time.
No.
Thank you.
Yeah, come on over here and sign the notice up here.
Oh.
Yeah. Once you've done that, then you're good to go, and head on over to their office, please. Whoop. All right, so that's it. As far as anything else is concerned, you guys are still 60 days behind. You haven't looked at what I established. You haven't looked at what the responses were. Matter of fact, or the lack of response, or what that would mean in a court of law, the lack of response. The fact that they didn't review the case
since Monday. And they attempted to review the case during the hearing itself. Not even 5 minutes before the hearing. During the hearing itself, he's trying to review this case. Now, what's even funnier is I spoke to him after court, after lunch. Yeah, I was still there. There was a lot going on in the background. He wanted to know why I was so damn confident, why I had so much evidence. Oh, wait a minute. Yeah, there is a lot of fucking video that's been submitted by me and the idiot Robert, condemning himself. Okay? In addition to that, Robert did not give a complete video. He gave a chopped up video to them because it has incriminating things that he said while he's sitting there trying to figure out what to do in the truck, and it recorded him saying those things. Oops. That's why we haven't seen the entire video, but you see, everything's coming out, folks. Everything is coming out. Everything. He's not going to be able to hide any of it. If he does, that's spoliation and obstruction. Go talk to a lawyer. You take all the paperwork. You got the money for it. Go talk to a lawyer and ask him how well I've set the civil case up now. This is just one leg of the civil case, folks. Just one. You'll have a good one. I'm going to have some relaxing music here. Stuff like that. You'll have a good one. May your God be with you. At least may be with somebody. Because your shit's not working.